Hi, good morning, and welcome to the monthly webcast presented by the Pro Bono Partnership of Atlanta. Today's topic is practical tips on how to conceive and grow your brand. My name is Anuj Desai, and I'm a partner with the law firm of Arnold Golden Gregory here in Atlanta. And if you can't hear me or if you're having any issues, please go ahead and let us know through the chat feature, and we'll see what we can do. Next slide. So on your screen there is our mission, the mission of the Pro Bono Partnership of Atlanta, which is to, again, maximize the impact of pro bono engagement by connecting a network of attorneys like myself with nonprofits such as yours in need of free business legal services. Next. On your screen there, you'll see some more information about Pro Bono Partnership of Atlanta, who's eligible to join, and other information. So, if you want more information, please do visit on the web at www.pbpatl.org. And again, you'll find all this information there online as well. Next slide. Legal information, again, I'm an attorney, but I'm not your attorney. And so this webinar presents general guidelines for Georgia nonprofit organizations. And so please keep that in mind as well. Okay, so we're going to go ahead and get started. And if you have questions, we'd love to have them. What you can do is go ahead and put them in through the chat feature. And we'll take breaks, every few slides or so. And if there are any questions, then we can repeat them back to the audience and talk about them. So today, again, we're here to talk about conceiving your brand and then growing your brand. A lot of you might already have trademarks, the name of your organization, or maybe you have different programs underneath it. And so those are all, in a nutshell, trademarks and brands sort of synonymous. And so a trademark or a brand can be many different things. It could be words, like on your screen there you see Habitat for Humanity. That's a brand or a trademark. And then it can also be a design or a logo, which you also see there on your screen. And then there's some of the more obscure trademarks like colors. So if you see a brown delivery truck, you think of UPS. Sounds, if you watch NBC, sort of the ding, ding, ding. Well, that's their trademark, and so there are different ways in which you can have a trademark, and it doesn't always have to be just words or a logo. It can be very creative, which is what makes it fun and a fun area of law. So let's talk about why do trademarks matter. So the first is it's a mental shortcut for either your customers or your intended customers, the people you serve. When they hear your name or when they see your logo, they immediately think of either what your organization stands for or what services it provides. And so as you grow your brand, you are solidifying that shortcut, and it tells people, which is the second bullet point, that your trademark or brand is a symbol of quality and reputation. And that is why trademarks and brands are so important in the long run, is you put all that effort behind building the reputation, building the goodwill, and then you want to make sure that you protect it, because consumers rely on that trademark to feel comfortable saying, I want to go there and use their services because I know that that brand represents something of quality and is well reputed. And what's the other reason for a trademark? It's to distinguish yourself in the marketplace. As you know, there are numerous nonprofits in Atlanta and nationwide. And you are all, in a way, competing for some of the same consumers of your services. And having a distinctive trademark will allow you to separate yourself from the pack and over time, it'll allow you to stand out. So that's another reason to have a strong brand. So we're going to step into stage one, which is sowing the seeds of success. Do you have any questions so far? Okay, none so far. Feel free to, again, type those in and we can answer them at the next break. So first, trademark selection. What's the goal here? The goal is, and again, this is if you're coming up with a new brand, or maybe you're rebranding, or you're coming out with a new program and you want to give it, a brand identity or a name. So the goal is you want to select a few potential marks to start out with. So these are your marketing folks or people brainstorming within your organization. And you want to be creative about it, and you want to come up with a few marks that stand out in the marketplace. And then what you're going to do is take those and whittle them down to one. But let's talk a little bit about the brainstorming process. So what you really want to look for and what you want to come up with are marks that are distinctive, strong marks. And you'll see on your screen some examples. So the first is a suggestive mark, which I've given an example, public heart. So public heart for, let's say, services of coronary disease counseling, something like that. The words public heart don't really describe what you're offering, but there is sort of the sense that it has something to do with the heart, it's for the people, and so it's suggestive. That's considered a strong mark because there's nothing in there that is immediately generic or descriptive of your services, which again is a reason it's going to stand out from the others. Another mark is called an arbitrary mark. So if you think of the trademark Apple, the fruit has nothing to do with electronics. That's why it's such a strong brand, because it doesn't describe the services, and so their competitors have no reason to use Apple in their branding, and so that stands out. So for example, you could use the trademark rock. Some people think it's sort of a show of strength that, hey, we're behind you, we're here to support you. And so the trademark rock for counseling services would be considered arbitrary. And then finally, the best type of trademark is something that's entirely made up, which is called a fanciful or a coined term. And some examples out there, Exxon is one, Xerox. These are all made up terms. And I give an example that just popped in my head, mezzanine, sounds funny. But the reason why a fanciful trademark is the best is because, again, A, it's going to stand out. There's not going to be anything else like it. But B, others in the marketplace would, again, have no reason to use that trademark. And so there's less possibility of overlapping in your same industry. And then the third bullet point, you definitely want to try and avoid marks that are generic. So something that is simply identifying what you are. Let's say Elder Care of Atlanta. Or descriptive, legal aid, which describes your services. If you pick a mark like that, and sometimes people do, what happens is that you can't protect it very well because somebody else should also be able to describe their legal aid services by saying, hey, we are legal aid of Marietta, let's say, and somebody says we're legal aid of Canton. You can't really stop them from doing that because it's a very descriptive trademark. So marketers often struggle with, hey, we want a brand that communicates what we do, and the lawyers say, no, 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 you can't do that because that's too descriptive. So a balance would be to pick, a type of mark from the second bullet point, something that's suggestive or arbitrary or fanciful, and then have a tagline underneath or next to it that describes what you do. So again, you could say Public Heart is your brand, and then in smaller font below, just have a tagline that says Coronary Disease Counseling Services. That way you communicate your message, but at the same time you're building a stronger brand overall. So we talked about trademark selection, and I said, pick a few different marks or brands. The next step is called trademark clearance. And this is the due diligence you do to make sure that you're not picking a brand that either somebody else already has out there in your field. And the test is not just identical. So you can't, just go out and say, well, nobody else has that exact spelling, or somebody has that spelling and I changed one letter, so I should be okay. The test really is something that's confusingly similar. So it's a broader test than just being identical. And typically an attorney helps you in this process because attorneys like myself have access to various trademark databases and also what are called sort of common law trademark databases, which look at use by businesses and entities throughout the country. Okay, so the goal is, again, you want to pick a mark, you come up with some names or designs, and you want to pick something that, again, nobody else really has in your space. And the reason for doing that, one is you want to avoid confusion in the marketplace. So if you look at the example there at the bottom, 100 black men, there's already an organization out there. You don't want to come out with 1,000 black leaders, right? Because somebody might automatically think, that sounds awfully close to 100 black men. Maybe they're related, maybe they're affiliated. And so what you're doing when you pick a name that's too close is, one, you're confusing people out there, but two, you're not respecting the intellectual property rights of the prior organization. And if 100 black men heard about your trademark, or you put up a website and you're coming out with that, you might very well receive a demand letter asking you to stop. And then all of that money and time you put in behind your brand will be for nothing. So a little homework on the front end goes a long way. You'll build a brand that doesn't infringe somebody else's, but also one you're comfortable knowing will be able to distinguish itself in the marketplace because it's not too similar to other brands. Okay, do we have any questions? No? Okay. Again, feel free to ask any questions you might have through the chat feature. All right, stage 2, cultivate your brand. So you've picked a brand, you've done the clearance, you know this is what you want, and you're moving forward with it. You're putting it on your brochures, it's on your website, you're providing services underneath that trademark. Everything's going great. So what you want to do at this point is protect it, right? You want to make sure that it stays distinguished in the marketplace, and that there aren't any other entities that are using similar trademarks, because again, that would cause confusion, and maybe consumers who are trying to look for your services might go to this other entity. The other reason for protecting your trademark and being vigilant in the marketplace is if you don't, and let's say lots of people start using the same or similar trademark for, in the same field, it might dilute your brand. And in doing so, you might lose your rights in it, to the point where if years later you try and stop one of these people, they'll say, no, you waited too long. And so you have to keep that in mind, is you can't, sit on your rights. You need to be vigilant. And how do you do that? So typically brand owners will have a trademark watch service, which is, a vendor that has specialized tools that automatically go out. They scour the internet, they scour trademark databases, and they try, and find things or names that are similar to yours, and then they let you know, at which point you can say, that's not too close, I don't need to worry about it, or yes, that's a problem, we need to reach out to them. Being a nonprofit, budgets are always an issue. So a free way to do this is through Google Alerts. So you can set up your trademark, your brand name into a Google Alert, so you get notified anytime that there's a mention of that, which hopefully will always be something you've done. You're in the press, something great happened, but sometimes you learn of other entities that are using your name, and then you can use that to contact them. So that's a quick way and a cheap way to do it. Let's say you learned through word of mouth or through one of these services that there is a problem out there. Somebody's using the same trademark as yours. What do? Um, you have to take action, of course. You got to protect your brand. Um, and one way to do it, keeping in mind, again, you're a nonprofit and your mission and your way of doing things is, of course, much different than, let's say, some international conglomerate out there. It's what I call the Southern Hospitality Demand Letter. And what you're doing is you're essentially, through an attorney or yourself, sending a very nice demand letter to the other side. You're saying, here's who we are, here's our brand, here's what we've invested in it. If you have a trademark registration, point that out. And you say, look, it seems like you inadvertently adopted something that's identical or confusingly similar to ours. And in doing so, you're hurting our brand, you're causing confusion in the marketplace, and we would ask you to stop. And let's discuss a way in which you can rebrand to something else over a period of time. And that way, we're both better off. Which is in stark contrast to a lot of attorney demand letters that you might have heard of, where it's very aggressive and stop now and give us all this money, or we're going to take you to court. Um, the demand letter I'm talking about is much more in line with your mission, and it's also something that can easily come from a business executive at your organization versus an attorney. So keep that in mind, as you do want to protect your trademark. Um, and there are different ways that you can do so. The best way to protect your trademark is to get a trademark registration. And you can get one through the United States Patent and Trademark Office, which will give you nationwide rights and exclusivity for your trademark. The prerequisite is that you must provide your services in interstate commerce. So either folks are coming in through interstate commerce to use your services, or you're advertising nationwide, or at least in more than one state. Um, if you're more Atlanta focused, or let's say Georgia focused, it's perfectly fine to get a Georgia registration. It's all much cheaper, first of all. It's much quicker. Um, and you'll still get exclusivity throughout the state. So there's two ways of doing that. Before you get a registration, be sure to put the little TM symbol next to either your logo or your trademark, the word mark. Once you get a registration, that's when you put the circle R. People always ask me, what's the difference, and am I allowed to use the TM? I don't have a registration. So now you know. You always have trademark rights once you start using it. That's when you put the TM. But once you get the registration, that's when you do the circle R. So again, keeping in mind you're a nonprofit, you don't have an unlimited budget. You want to be conservative. You don't want to try and register every single trademark that you have. You want to keep in mind, for example, how long will I use this brand? Maybe it's something that you're only going to use for a few years, or you're not sure, because down the road there's going to be an entire rebranding effort. So think about that. Think about what your primary trademarks and brands are, and then see which ones you want to go register. Now, of course, if you're getting a Georgia registration, it's much cheaper, so you can afford to get a lot more in terms of Georgia registrations. And just to give you sort of an idea, in terms of just government fees, a federal registration costs somewhere between $225 to $285 per trademark per what they call class of services. And in Georgia, I think it's like $30 or $40. So big difference there for you. And then you see on your screen there, you still have common law rights in your mark. And so that's a misunderstanding that folks often have is, I don't have any rights until I go get my registration. And that's not true. The minute you start using your trademark out there in commerce, you have trademark rights. In the US, you get trademark rights through use. You can go get a registration to get additional protection exclusivity and certain other benefits. But even if you decide you can't afford a registration or you don't need one, you still have rights. And if somebody else popped up, 2 years later using the same trademark, you can send them that nice demand letter and tell them to stop. Um, Not having a registration won't stop you from doing that. Also, be smart with your budget and keep in mind that applications to register marks can be refused. So, for example, if you do apply to register legal aid of Marietta, the trademark office might say, sorry, that's too descriptive, and we're not going to give you a registration and prevent others from using that trademark. Um, there's certain ways you can get around that sometimes, but you want to think through all those issues. Maybe you know of some other trademarks out there that might be considered confusingly similar. If you go to apply, the USPTO might say, we can't give you a registration because of these other registrations out there. So evaluate those risks before you invest the money into going and getting registrations. Uh, so let's look at a couple examples here on the next screen. One is Action Ministries. So here you actually have several different trademarks. You have Action Ministries, that's one. You have the logo of the individual with the sort of arc over the individual. And then you have the phrase leading people out of poverty. Um, if you have, if you don't have an unlimited budget, you may say, I'm only going to go register Action Ministries for now. Then maybe later, if you use the individual logo a lot, you might go register that. The tagline, leading people out of poverty, those change pretty often. That's not your core brand. So maybe you would omit that and not worry about that expense. Um, the other one, Bird's Big Adventure, um, with the star, um, you might go register the words Bird's Big Adventure. But otherwise, there's not sort of a unique design element to the wand with the star. Um, the font is simply stylized. And so you might say, you know what? Getting the words registered is enough because that will give me the protection I need overall. And there's nothing really distinctive in the design that I want to stop other people from using. If other people use, stars with their names, that's fine. So think through those types of practical issues as you move forward in registering your brand. Yeah, the question was, how long does it take to get a trademark registration? And it used to be, so two different answers depending on where you do it. With the USPTO, so at the federal and national level, it used to be that it would take anywhere from 14 months to 2 years. Um, but with advances in technology, that's come down quite a bit. Assuming that there's no problems with your application, you might see your registration in about 8 to 9 months. Um, and if there are issues, it could take longer. I'd say with Georgia, you're probably looking at 4 to 6 months. So very quick, very easy. And keep in mind, it's not truly the registration date that matters. It's the application date in terms of priority. Um, and so, again, first, the day you begin your use is the date of priority versus everybody else. But getting your application on file also gives you priority. So if somebody else comes and applies after you, then you have priority over that application. And this application might be suspended if the trademarks are conflicting. So keep that in mind. You do want to be timely in trying to register your marks once you decide which ones you want to register. Okay, so we've got a registration. We're protecting our brand. Stage 3 is grow your brand. So using your trademarks, you need to be using your trademarks continuously. There can't be a break unless you have, a good excuse. For example, let's say you only put on a seminar every 2 years. and it's under a certain brand. That's okay, but you can't start using a trademark, stop for a few years, start up again. Um, if you do that, there's going to be a break in the chain of priority, and if you've been deemed to abandon your trademark, somebody else could come in between and start using the same trademark or the same services, and you might not be able to stop them. So it's always important to use your trademarks continuously. You want to reevaluate periodically. Are you providing new services? If you are, you might want to go register your trademark in relation to those new services. When you register a mark, it's not for anything and everything. You have to identify the products or services you're offering under that mark. And so as you enter new markets, you want to go revisit your trademark registrations and see if you need to apply for new ones. Likewise, let's say you exit a service area or you no longer provide some type of products. You want to make sure that when it comes time to renew your registration, you look at the description of goods and services and say, wait a second, we're not providing counseling services anymore. You need to omit that from the registration. Because if you don't, your registration could become vulnerable to cancellation by some other entity that wants to use the same trademark for, let's say, counseling services. And the trademark office takes that very seriously. And often it's just inadvertent, it's an omission. But the real issue for the government is some people often fraudulently register trademarks with things they never intend to use them for, just to keep everybody else away. And that's what they're trying to avoid. So just be careful as you renew your marks or you decide to get new registrations. Take stock of what you're doing and then make sure it reconciles correctly. Another thing, very important, your trademark is not a verb. How many times have you told someone, hey, go Google that? Or hey, I'll Google that for you. Google is not a verb, but in our vernacular, it has become a verb. Google hates that. If you ever look at one of their ads or if you go on their website, it will always say Google search because Google is a brand. And when you use a trademark generically, it could lose its value as a trademark and all of the rights associated with it. So here's some examples of brands that you might think are actually not brands. Popsicle, that's actually a trademark. Thermos, also a trademark. Frisbee, I just learned that the other day, also a trademark. But I bet you each and every one of us refer to these things very generically. It doesn't make matter who makes the popsicle. An ice pop to us is just a popsicle. So you don't want that to happen to your brand. So always use your trademark as an adverb or some attributive modifier, or if it's the name of your organization, that's okay. But try not to take words from your trademark and then use it as a verb in marketing. Marketers love doing that, but you should not do that because that again might make your trademark vulnerable to becoming generic. Another important lesson is to use your trademarks consistently. Spelling matters. Punctuation matters. There's an example there on your screen. When you go register your trademark, you present it as, let's say, Braille-ease. At certain points, you're going to have to prove to the government you're still using your trademark. It's called a maintenance filing. If you go and provide a maintenance filing with something that says Brailleese with that hyphen missing and one E missing, they're not going to let you do that. They're going to say that's not what you registered. And then you might have to, try and go amend your trademark registration to reflect how you're actually using it. But it's a big pain, it's a big expense, and there's no guarantee you'll be able to do it. So take a good look. This is part of the creative review process in your organization. Is as you put out brochures, as you put out website copy, take a good look. Make sure you're always using the trademark same spelling, the same presentation as you have before. This is especially true with design marks. Logos, various logos that you've seen in your lifetime, they change over time. If you think of Wendy's hamburgers, the girl, she's changed over several decades. Um, and and so let me give you an example. There on your screen, you'll see the New York City Ballet trademark with the logo, which is in the before column. And then you've got the after, which is, the more modern sort of look there. Um, in that case, they decided to make a clear shift. They're going to something totally different. And when you do that, once you stop using the old one, you abandon your rights in it. And others who come along and start using something similar, you can't stop them. So, if that's your intention, that's fine. But if you're inadvertently changing your design or modifying it slightly, just know that you might lose rights in it. The other graphic there on the screen is the Firefox browser logo. And as you can see in '05, it was sort of this bird with flames. Um, and then in '09, it moved to the fox, covering the globe. And then as you look onwards, it doesn't really change that much. There's just minor changes. Um, and that's okay. That is allowed because it's not a material alteration. The What you see there in front of you still looks roughly the same. And usually the trademark office says that's okay. Um, so if you do want to do a refresh of your brand or you want to make it look cleaner or more modern, let's say, just keep that in mind. If you don't want to lose your rights for over all those years in the design, just make minor changes to it gradually. And that way you can have this continuum and the design mark will be protected, forever and ever, as long as you keep using it. Okay, do you have any questions? Okay. So stage 4 is harvest the goodwill. So now you're using your trademark, you're protecting it, you've got it registered, you're doing all the right things. Um, you can actually, you know, make some money from it. You can license your trademark. So let's say you have a brand like NPR that people love to show off, and you want to be able to allow others to use it. You can license your trademark, and you can license it, let's say, to an apparel manufacturer or people who put out coffee mugs or anything like that. Um, what you want to make sure is that when you do license it, you still retain control, quality control over whatever products are being put out, control over how your mark is presented on those products. It's called so let's say your nonprofit is merging with another one, or maybe you're acquiring one, or let's say just a group of services is being um, siphoned off, or not siphoned off, but is being sold away or conveyed away to another entity. And when you do that, you can assign both your trademarks, your registrations, all to the other entity, or like I said, you might be taking on another entity's trademarks. When you do that, just make sure you're also assigning the goodwill that goes with their trademarks. Otherwise, the assignment briefly about domain names. Um, and as I'm sure you're familiar with, you can acquire domain names to support your brand. Often they're the same name as your brand with a .com or .org. But just keep in mind that a domain name is not necessarily a trademark. It can be, like overstock.com, for example. Um, but unless you're using that as your trademark with the .com, it's not. Also note that there are a lot new generic top-level domain names coming out. So you have .org, but they're coming out with .ngo, and other such GTLDs, they're called, that might be appropriate for your product or service area. And so keep that in mind. If you want to make sure you have the best web presence out there, search those out and make sure that they're still available to you. Sometimes you have the issue of cyber squatters, people who acquire domain names just to sit on them and then hold them at ransom, basically, to sell them to you. If you have that kind of issue, an attorney can usually help you with what's called a UDRP procedure, and that's a proceeding that's not really in court, but it's before a third domain name. We'll talk briefly about social media. Um, so you want to be careful in how you use social media. Everybody's using Twitter, Facebook, Instagram, and other such social media platforms these days. Um, but unlike an individual or let's say somebody in the news industry, you have to be careful what you put out there. So if you find an image, let's say on the web, that goes perfectly with some text you want to copyright permission for that image, what if there are people in that image? Let's say an employee took a picture of some event and then you want to share that. Did you get releases, right of publicity releases from those individuals? If you didn't, again, depending on who's in the picture or if they don't want to be, you know, identified publicly in that way, you might have some sort of dispute brewing there as well. And then just always part of the creative review process, um, have checks and balances in what's put out. You don't want one employee, for example, to have the login password for every platform. You want to make sure that that's available to management in case there's an issue with the employee leaving, or you might have sometimes issues with rogue employees who just type whatever they feel like into the social media platform, like tweets, for example. You want to bring that process in under the same review process that happens for any marketing material, just to make sure that there's a second set of eyes that look at this stuff. And in a moment, we'll talk about what that means. But I wanted to point out that social media can be trying, it can be painful, and you have to have the resources there. So, for example, if you're, let's say, you have to have the people there to be able to respond to those and to say, we appreciate your feedback. Please direct message us or please send us a message, and we'd like to discuss this with you so we can address your concerns. That's a lot of work. And so if you're investing in social media, you want to make sure you have the manpower to support it. People who put out fresh content. You don't want something started in 2012 and then it's 2015 and you didn't write anything for 3 years, because that makes you're not doing anything anymore. So keep that in mind as well. The example I mentioned a second ago, uh, I'm sure everybody recalls Komen for the Cure and Plant that issue that have cropped up recently. You want to align your brand to your message, and this is why creative review is so important. If you're putting out a message in social media or any marketing really, um, has it gone through various levels of review to make sure you're aligning your brand to your message? Because if you don't, you might have the issue that they experienced where somebody said something that maybe top level management didn't clear, and now it's become a PR disaster. So walk through the copy, walk through the marketing materials, the social media messages. Make sure it aligns with your brand. Mistakes will happen, something will be said inadvertently. Just have a crisis plan in place so that you can address that. Ultimately, the end goal is to protect your brand, to make sure that it doesn't suffer or get damaged because of some sort of customer issue or PR issue. So that brings us to the end of our presentation. Again, apologies for the technical issues, but if you have any questions, I'm not sure if we have any at this time. Okay. Well, we appreciate your attention today, your participation, and of course your patience. Again, this was a presentation on practical tips on how to conceive and grow your brand. Thank you again. And if you have any questions, feel free to contact Pro Bono Partnership of Atlanta. Have a good day.